President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honourable Senators have granted leave of absence to Senator Ronald Huggins, who is ill. Honourable Senators, I am awaiting the instrument of appointment, so with your leave I will revert to this item later in the proceedings.
From the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Madam President, I have the honour to lay on the table the following papers. As listed on the order paper, the supplemental order paper, in the name of the Minister of Finance. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Mayaro Rio Claro Regional Corporation for the year ended September 30, 2008. The ministerial response of the Ministry of Finance to the 13th report of the Public Accounts Enterprises Committee, 3rd Session, 2017-2018, 11th Parliament, on the examination of the audited accounts, balance sheets, and other financial statements of the Union Estate Electricity Generation Company Limited for the financial years 2008 to 2015, and the ministerial response of the Ministry of Finance to the follow-up report of the Joint Select Committee on State Enterprises, 3rd Session, 2017-2018, 11th Parliament, on an inquiry into the administration and operations of Caribbean Airlines Limited. Thank you, Madam Chair.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Public Administration and the Attorney General. The ministerial response of the Ministry of Public Administration to the 18th report of the Public Accounts Committee, 3rd Session 2017-2018, 11th Parliament, on the examination of the audited financial statements of the Airport Authority of Trinidad and Tobago for the financial years 2008 to 2012. The ministerial response of the Attorney General and Minister of Legal Affairs to the 17th report of the Public Accounts Committee, 3rd Session 2017-2018, 11th Parliament, on the examination of the audited financial statements of the Trinidad and Tobago Bureau of Standards for the financial years 2009 to 2013.
Reports from committees.
Senator Hussain.
Thank you very much, Madam President. I have the honor to present the following report as listed on the order paper in the name of Senator the Honorable Dennis Moses. The 8th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd Session, 27-2018, 11th Parliament on the examination of the perceived inequality faced by single fathers in Trinidad and Tobago, with specific focus on custody matters, policies, and access to programs and services. The report is listed on the order paper in my name, the 9th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd session, 27-2018, 11th Parliament, on the examination of the treatment of detainees and conditions at holding cells in Trinidad and Tobago police stations. Thank you.
Minister of Agriculture, Land and Fisheries.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the order paper in the name of Senator Sophia Choate, Senior Counsel. The 4th report of the Joint Select Committee on Finance and Legal Affairs, 3rd session 2017-2018, 11th Parliament on an inquiry into certain aspects of the national insurance system of Trinidad and Tobago. I thank you. Urgent questions?
Senator Mark.
Thank you, Madam President. To the Honourable Minister of Works and Transport. In light of the dry docking of the Cabo Star last evening and the absence of any alternative cargo vessel to replace sail, can the Minister advise what is being done to mitigate the impact of the lack of such a cargo vessel?
Minister of Works and Transport.
Thank you, Madam President. Madam President, the Trinidad and Tobago Inter-Island Transportation Company Limited advised by press release that from September 20th, 2018 to September 30th, 2018, the MV Cabo Star will undergo its planned annual maintenance program at the Caribbean Dry Dock Yard. Hence, for the 10 days that the vessel would be on dry dock, the authority has put in place the following contingencies measures. Additional sealing of the MV Cabo Star was scheduled on Saturdays during the period Saturday 26th August 2018 to 15 September 2018. Vehicles up to 7,000 kgs will be accommodated on the TNT Spirit during this period of dry docking. Sealing of the TNT Spirit on Wednesday 19th and 26th September during the dry docking period was scheduled. I thank you.
Madam President, can the Honourable Minister indicate whether the TNT Spirit will be taking up the slack left by the Cabo Star during this period of dry docking? For the period, it would start from today right until the return of that vessel on the 30th, Madam President.
Minister.
Thank you. Madam President, the Cabo Star is a cargo vessel. The TNT Spirit is a passenger vessel. However, vehicles up to 7,000 kgs will be accommodated on the TNT Spirit. This dry docking was planned, and the stakeholders, both in Trinidad and Tobago, would have been consulted. There have been additional trips, and up to the day before the vessel went into dry docking, significant volumes were utilized on the cargo vessel. So it is anticipated that the TNT Spirit will take the cargo that is below 7,000 kgs. Thank you.
Senator Mark.
Yeah. Madam President, can the Minister indicate whether the bulk cargo that is normally transported by the Cabo Star via the truckers that would enter the dock to dispose of such goods on the Cabo Star, can the minister give this country the assurance that the TNT Spirit would be able to fill that gap in terms of the cargo that is required?
Minister.
Madam President, this dry docking is the annual planned dry docking. This is not the first time that we have to send any cargo vessel working in service to dry docking. And this is why, again, it was a planned dry docking where the stakeholders would have be given ample notice. Most of the bulk cargo that has to go to Tobago would have been transported over the last 2 weeks with extra sealing. Everyone was informed that the cargo to go on the TNT Spirit would have to be cargo that is less than 7,000 kgs for this period. I thank you.
Questions on notice, questions for all answer.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government is pleased to announce it will be answering questions number 184 and 185. We ask for a deferral of 2 weeks to questions 186.
Mr. President, I seek your guidance and indulgence here because these matters have been on the order papers, for some time now. And the Honourable Leader of the House is aware that within a few days from today, Parliament would prorogue. So to really ask this Honourable House, through you, to have these matters deferred for 2 weeks, I think he needs to be a little more serious than that.
Senator Mark, question 184.
Yeah. Thank you, Madam President. Question 184 to the Honourable Minister of Agriculture, Land and Fisheries.
Minister of Agriculture, Land and Fisheries.
Madam President, I thank Senator Mark for this question. In relation to the issue of the National Quarries Limited operating without mining licenses, this came out of a joint select meeting held on Monday, 29 January 2018. A subsequent advertisement in March 2018 confirmed that the National Quarries had sought to renew certain mining licenses. Madam President, my understanding is that that is in progress with the Ministry of Energy and Energy Industries. With respect to the EMBD, it is public knowledge, Madam President, that the government took steps to deal with this issue which existed since 2003. The EMBD is working with the Ministry of Energy and Energy Industries to obtain the appropriate quarry licenses. Thank you.
Can the Minister indicate how long will it take for both National Quarries and the EMBDC to secure those licenses from the Ministry of Energy?
Minister.
Madam President, in relation to National Quarries, I could tell Senator Mark that I spoke to the CEO who indicated to me that they're working with the Ministry of Energy and Energy Resources and they hope to have those licenses in place shortly. In relation to EMBD, I could say that Cabinet has approved the grant of the mining licenses. EMBD has prepared the check for the fees to be paid, and we expect that very shortly the EMBD's licenses will be in place. Thank you.
Thank you, Madam President. Madam President, through you to the Honourable Minister. Minister, can you tell us in relation to National Quarries Limited, how long was National Quarries operating without the requisite licenses from hence go back?
Minister.
Madam President, I'm not in a position to provide that information. As I indicated in the answer, the commentary attributed to me arose from the Joint Select Committee meeting of January 29, 2018, and perhaps the record of that meeting would supply the details, but I'm not in a position to supply that now.
Madam President, thank you again. Through you to the Honourable Minister. Minister, is there any legal consequence that arises from National Quarries operating without the requisite licenses?
Madam President, that is a matter for the regulator, the Ministry of Energy and Energy Industries, to determine whether anything arises from not operating or operating without a license.
Senator Mark? You had wanted to ask a supplementary question.
No, okay, thank you, Madam. Just wanted to ask the Honourable Minister, what time frame, because, Madam Chair, or President rather, we are hearing this thing will be done shortly, but this thing has been going on for some time now. So I'm asking the Honourable Minister, through you, what can he identify rather, a period where the national quarries would be able to secure their license formally from the Ministry of Energy and Energy Industries?
Senator Mark, I believe that was posed by Senator Ramdeen as his first supplementary question about the time frame. No? You want to ask another question, supplementary, because that question was posed about the time frame. Yes, Senator Ramdeen asked how long, wasn't it? Senator Mark, ask another question. That question has already been, the timeline has already been asked of the minister. Yeah? Okay, next question, Senator Mark.
Question number 185 to the Honourable Minister of Education.
Well, Senator Mark, before I call on the minister, could we revert to question 184? It is my misunderstanding. Pose your supplementary question to the minister. Minister, do you remember what Senator Mark wanted to ask? Yes, sure. Can you answer, please? It's my misunderstanding. I apologize.
Forms. Yeah. So let me be very clear. Madam President, with all due respect to Senator Mark, I am not the line minister for national quarries, and I'm not responsible for the issue of the licenses. But out of regard for Senator Mark and appreciation of the question, the issue arose from a joint select committee, and that is why I commented publicly, because I'm the line minister for EMBD. I could speak with clarity on EMBD, but not on national quarries, except to say that I spoke to the CEO a short while ago, and he indicated to me that they've been working closely with the Ministry of Energy and Energy Resources, both on the licenses and their plan for quarrying up in the Northeast. Thank you.
Next question. Senator Mark.
Okay.
Let's do it formally.
Okay. Question number 185 to the Honourable Minister of Education.
Minister of Education.
Thank you very much, Madam President. Madam President, in spite of the fact that Senator Mark and I share a very special relationship, he's my very good friend, this question is based on the wrong premise. There has been no cost or no systems that have been put in place. There have been no procurement procedures that we have entered into. But let me explain. Madam President, UTT currently utilizes a student management system which is limited to student applications and records, but is not integrated with finance, human resources, and other management systems. Record keeping is cumbersome and prone to errors. Most universities around the world utilize integrated management systems which significantly enhance the efficiency of the operations. Banner is one such integrated system that is widely used internationally at institutions which include UWI and the COSTAT. Banner has been in contact with UTT for more than 10 years, promoting the use of their software at UTT. Over the past 6 months, personnel from Banner have visited UTT to evaluate the needs of the organization and assess the current methodologies used for information processing and record keeping. The outcome of these visits will be a proposal to UTT for an integrated management system utilizing standard modules but tailored to the specific needs of UTT. This proposal is yet to be received, and no decision has been taken by UTT or its board regarding the acquisition of any software. All discussions between UTT and Banner to date have been exploratory. Formal procurement procedures will be utilized by UTT for the tendering, evaluation, and acquisition of and the software related to the integrated management system. Thank you very much.
Senator Mark.
Madam President, can the Minister indicate whether he's aware that some $45 million have been allocated by UTT to introduce this new ICT system, which would be able to provide services, or which would be implemented, I should say, over a 3-year period? Is the Honourable Minister aware that some $45 million of taxpayers' dollars have been allocated for that purpose?
Minister.
Madam President, I am not aware that any money has yet been organized or appropriated or envisaged. All I can say is that we are in exploratory discussions and no decision has been taken as yet. Thank you.
Senator Mark.
Can the Honourable Minister share with us a time frame for the conclusion of these discussions with a view to arriving at a decision?
No, Senator Mark, I won't allow that question. Next question. Supplementary. Okay.
Request for leave to move the adjournment of the Senate on definite matters of urgent public importance.
Senator Mark.
Madam President, I hereby seek leave to move the adjournment of the Senate today under Standing Order 16 for the purpose of discussing a definite matter of urgent public importance, namely the continuous failure of the government to adequately maintain the nation's sea bridge. The matter is definite because it pertains specifically to the continuous failure of the government to adequately maintain the nation's sea bridge by not providing an alternative vessel in light of the dry docking of the Cabo Star. The matter is urgent because the Cabo Star will be out of commission until September 30th, which will once again result in loss of revenue for businesses in Tobago. The matter is exacerbated due to the fact that with the upcoming holiday weekend, businesses in Tobago will not be able to take advantage of the expected influx of persons to the island. The matter is of public importance because the continuous lack of a reliable inter-island transport service adversely affects Tobago's economic health. I so move, Madam President.
Honourable Senators, I've considered the motion and I am not satisfied that this matter as presented qualifies under this standing order.
Government Business Committee stage.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Amend the Interpretation Act, Chapter 301, Summary Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Bail Act, Chapter 460, the Administration of Justice Deoxyribonucleic Acid Act, Chapter 534, the Legal Aid and Advice Act, Chapter 707, the Child Rehabilitation Center Act, Chapter 1305, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Children Act, Chapter 4601, the Children Community Residences, Foster Care and Nurseries Act, Chapter 4604, the Children's Authority Act, Chapter 4610, and the Family and Children Division Act 2016 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Bail Act, Chapter 460, the Administration of Justice Deoxyribonucleic Acid Act, Chapter 534, the Legal Aid and Advice Act, Chapter 707, the Child Rehabilitation Center Act, Chapter 1305, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Children Act, Chapter 4601, the Children's Community Residences, Foster Care and Nurseries Act, Chapter 4604, the Children's Authority Act, Chapter 4610, and the Family and Children Division Act 2016 be committed to a Committee of the Whole Senate forthwith to be considered clause by clause. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The Senate shall now go into Committee of the Whole to consider the bill clause by clause. Honourable Senators, before we begin, I just want to treat with some housekeeping issues. All members should have distributed on behalf of the Attorney General the bill with all the track changes. You should have a document with the rationale for the amendments. Yes? I hope I'm not speaking to myself. Yes, members? And then today there was circulated a list of proposed amendments on behalf of Senator Mark. Is everyone in possession of these documents? Attorney General.
Just indicate also for the assistance for better assistance to all senators, I also circulated by email through the clerk all of the laws as proposed to be amended in marked up version as well, so that the amendments could be factored in context.
Yes, Senator Raful.
I don't have the hard copies with me, and my soft copies are not downloading onto my computer. Can I request a 2-minute break so I can just have some assistance with my computer?
No, we will furnish you with some of the copies.
Great, thanks.
All right? The
Madam President,
Yes.
before we begin, can I just simply express my deepest sense of gratitude to the Attorney General for the documents that have been submitted, both in track form changes as well as the bundle of documents that was submitted with all of the laws that encompass all of the amendments that are to be done. It was very, very helpful. I did indicate to the Attorney General that on this part of the opposition, we've tried to do the best that we can in terms of circulating the written proposed amendments, but we would like to be able to go through those that have not been circulated while we go through the committee stage.
Madam Chair, Senator Ramlin did indeed say to me exactly as he's just said. And of course, the government welcomes any suggestions that could take us to a better place with respect to this bill, subject, of course, to your guidance.
Clause 1.
Honourable Senators, the question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
Honourable Senators, the question is that Clause 2 stand part of the bill. The question is that Clause 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that Clause 3 stand part of the bill. May I just point out that we have for Clause 3 amendments circulated by the Attorney General. No? No, not by Senator Mark alone. So, Senator Mark?
Yeah, Madam Chair, my colleague will assist me on this one as well, but let me begin by indicating that we are just a couple of days away from being a republic, representing the 42nd anniversary, I should say, of republicanism. And I just wanted to let you know that we are suggesting that what the government is proposing is not in keeping with what we would like to have established at this time on behalf of the citizenry. And as you would know, when you go to this particular provision of the legislation, the word England is used, and there has to be a context for this interpretation of that particular word. And it is so broad and so wide. At this time, we are suggesting that as a modern, democratic, sovereign, independent state, we would want to suggest to the Attorney General that we delete that term or that word England, because as you would imagine, Madam Chair, that would have come into being during and before independence, when judges were being brought from London in many instances on the bench here. And it was retained, as you would know, subsequently. So in the current reality that we are in, we are suggesting that the Attorney General give serious consideration to its deletion, the word England, and to substitute instead the words any Commonwealth Caribbean country, because we again believe that as part of with the whole Caribbean Court of Justice concept that the government has been promoting, we have the view that this question of bringing judges conscious of the reality of culture and context, it would be more appreciated and appropriate for persons who are in that place to be located within the Commonwealth Caribbean as opposed to the entire Commonwealth as is being suggested. And Madam President, we are proposing further that we again delete where the word England appears and substitute any Commonwealth Caribbean country. And that, again, Madam President, is trying to ensure that we do not have strangers coming in our midst right from jurisdiction outside of the Commonwealth Caribbean. So I hope that the Attorney General would understand that we are trying to address a very, very sensitive issue, and that he would give consideration to our proposal. But my colleague, Senator Ramdeen, I would like him to further elaborate on this particular provision that we are putting forward for consideration.
Thank you, Madam Chair. Madam Chair, through you to the Honourable Attorney General. Attorney General, there are 3 points that I wish to make on the proposal that Senator Mark has put forward for your consideration. Firstly, the rationale, as you have done in your, I'm trying to set out what the rationale is. The rationale, firstly, is that I think we've come a very long way from where we were at independence to where we are now. And I think it is either in your contribution or I think it's the contribution of Senator Choate. It was described that in 1962, all of the judges of the Supreme Court would have been members of the English bar. And I think when you look back at Act number 14 of 1964, where this particular provision in the Supreme Court of Judicature Act comes from, I think the rationale was clearly at that point in time, we didn't have a fused profession. And therefore, there was, if you wanted to become a barrister, you had to go to England and do the courses, or if you wanted to become a solicitor, in order to incorporate those professions into our unfused profession at that point in time, these qualifications were put there. I think it was raised with you before, during the debate, that one of the ways in which we would like to see the profession move forward is that if you are going to be a member of the judiciary, whether it be in the High Court or the Court of Appeal, one would have expected that you would at least be qualified to be a member of the bar. And therefore, that is where the rationale for the first requirement is, that I think we've come so far that I don't see that there is a need for us to continue to have a requirement that you can be qualified as to be a member of our judiciary by being a member of the Bar of England. And just to use an analogy, when you go back to the Legal Profession Act and you look at the way in which someone from our jurisdiction, if they have to be a member of the Bar of England, there are certain mandatory courses that you have to do, EU law and land and trust and these kinds of things. And therefore, I want to ask whether you would consider that we shy away or we come to an end for this requirement that if you are qualified to be a member of the Bar of England, that gives you a qualification to be a member of the judiciary. That's number one. Number two is that we've asked that you consider whether you would delineate or limit the Commonwealth categorization that you've proposed by being a member of the Commonwealth Caribbean. There are 2 things that arise from that, Attorney General. Firstly, I think it accords with us as a CARICOM country. It recognizes the fusion and the way in which the legal profession operates by the fact that we have 2 law schools that give you 3 law schools that gives anyone who is qualified the right to practice throughout the Caribbean. And I think that it falls well in line with the fact that even though Senator Prescott made some reservations about which Caribbean country you come from, I think we all are bound together by a certain degree of commonality that would give each person who belongs to a member of the Commonwealth Caribbean Bar a certain degree of unique knowledge of the culture that binds us together as a Caribbean country. And that is the rationale for that. But there is a third thing that came to mind this morning that raises a little bit of a concern, and it's quite a serious concern. If we have anyone from the bar of a Commonwealth country coming to become a member of the judiciary, they would obviously be entitled to all the benefits that are attributed to someone who is working here. But if that person is not a Trinidad and Tobago citizen, the issue will arise about they have to get a work permit to work here if they're outside of CARICOM, because we wouldn't have that problem with the freedom of movement inside of CARICOM. But if you have someone who is outside of CARICOM coming into Trinidad and Tobago to become a judge, and it happened before when we had a judge from England on the bench, Brooks, right? I don't know how it was done. But there is something serious for you to consider as Attorney General, which is that person will have to apply for a work permit. And that work permit has to be granted by a Minister of Government. And there will be an issue about the boundaries and how that relationship is. It is something that can lead to some kind of challenge, constitutional or otherwise. And that's probably one of the things that arose out of my research into this. And perhaps you can clear it up. But I really think, Attorney General, that I applaud the fact that you are increasing the number of judges in the High Court and the Court of Appeal. I think it's a step in the right direction. But I think that the time has come for us to decide whether we want to continue allowing. I don't know that it reciprocates, that a member of the Trinidad Bar could be, I'm sure, cannot be a member of the judiciary if the United Kingdom, Ireland, and Wales. And therefore, we are conferring a benefit on people who we do have a reciprocal benefit to our citizens. And I think the time has come for us to do away with that. I think that in accordance with the things that you've said, and I do understand your argument.
Senator I think you've made the points on the proposed amendment, and I'm going to invite anyone else, because I think you've covered all the points that you wanted to make. Anyone else wants to say anything on the proposed amendment? Senator Choate?
Thank you, Madam Chairman. Actually, it's just a question which occurred to me arising out of the closing of the Honourable Attorney General at the last session. Does this mean that citizens of the Republic of Trinidad and Tobago who are admitted to the bar of England and Wales can bypass the procedure required for admission to the bar here and make an application to the bench, as is now being permitted to all members of the Commonwealth? So I just wanted to know if it was possible to clear that up.
Any other question or comment before I ask the attorney? Yes, Senator Hussain.
Madam Chair, just one query. In terms of the number of judges, I just wanted to find out from the Attorney General where did the figure 65? Why we increase so much in terms of
okay, but we're dealing right now. Let's deal with the amendment that has been proposed by Senator Mark. Sure. That's what we're treating with right now.
Okay, I'll raise the query later on.
Sure. Any other member wishes to say something or raise an issue with respect to the amendment proposed by Senator Mark? Attorney General.
Much obliged, ma'am, and I thank my learned colleagues for their contributions. May I begin by acknowledging the bona fides of the philosophical and esoteric exhortations with respect to the boundaries of admission to the judiciary. It is true to say that we have advanced as a republic since our days at independence, when in 1962 we had the Supreme Court of Judicature Act, and in 1964 we had these amendments by Act number 14 of 1964. If I could be permitted to answer Senator Choate's question first, yes, Senator, it is correct that there can be a technical bypass, but it is not something which is recent. It is something which is and has always been the case in this particular Supreme Court of Judicature Act since at least 1964, when the amendments to introduce the qualification for the Bar of England first arose. So it is possible for a Trinidad and Tobago citizen who has qualified at the Bar of the United Kingdom and who has been in practice for over 10 years and who meets the requirements of 18 years ago, that is the scheduled requirements issued under the Supreme Court of Judicature Act, under the Constitution, under Section 105 of the Constitution, to technically come in without being admitted to the Bar of Trinidad and Tobago. But that has been the case since 1964. With respect to Senator Mark's specific amendment, as factored by Senator Ramdeen's fulminations, which I acknowledge as genuine thoughts for us as a Senate and as a republic, may I say that the recommendation coming from Senator Mark is that we effectively remove that which we have operated since 1964. Remove the admission to the Bar of England and now get rid of it once and for all. But that must be respectfully factored in the context of the very issue that we're wrestling with on the practical side. And that practical side is essentially the fact that we require more judges. England is effectively the birthplace of our Commonwealth jurisprudence, but more particularly, our final court of appeal pursuant to Section 109 of the Constitution is the Privy Council. Therefore, moving away from the anchoring into the jurisdiction, the Commonwealth, the common law jurisdiction in the United Kingdom, whilst we treat with it at our High Court and Court of Appeal level, that's the Supreme Court of Trinidad and Tobago, it is a contradiction unless we treat with it at our final Court of Appeal level. Now, as we know, the appellate jurisdiction in the CCJ is only exercised by Trinidad and Tobago with respect to matters of original jurisdiction, meaning matters to the Treaty of Chaguaramas. We did not have the final Court of Appeal as the CCJ being adopted for reasons which I won't go into right now, but suffice it to say, without unanimity between opposition and government, that cannot happen. And whilst government is readily and has always been readily able to consent to that, that has not happened. So the move away from England at present would be extremely complicated because our final Court of Appeal, the Privy Council, would still be England. If we get to now the bona fides of restricting in the argument, the bona fides in the argument of restricting Commonwealth to Commonwealth Caribbean, again I must have reference to 4 particular points of call. Firstly, Section 109 of the Constitution, which prescribes the Privy Council as our final Court of Appeal. And under the rules of engagement for the Privy Council, any member of the Commonwealth can in fact sit in the Privy Council. Secondly, with respect to the CCJ, where we have original jurisdiction locus as a country, the CCJ itself permits not only Commonwealthers, if I may use that expression, to sit on the CCJ, but it expressly also permits persons from the civil law jurisdictions, that is outside of the Commonwealth, to sit in the CCJ. And I draw immediate reference to Mr. Justice Witt, who sits on the CCJ, coming from the civil law jurisdiction of the Netherlands. That is a non-Commonwealth country. I then take refuge in the third position, which is that the other jurisdictions in the Commonwealth Caribbean, which we are asking ourselves to be limited to, those appellate jurisdictions, and I refer to the 9 territories that comprise the Eastern Caribbean, I refer to the Bahamas, I refer to the Cayman Islands, I refer to the BVI, I refer to Belize, I refer to Turks and Caicos. All of those jurisdictions allow for Commonwealth persons to be in that appellate jurisdiction and Supreme Court jurisdiction. The last port of refuge, which I will ask honourable senators to consider, is the Legal Profession Act. The Legal Profession Act, in fact, allows for persons from the Commonwealth with suitable qualification to be practitioners in Trinidad and Tobago, provided that they meet certain prescribed elements in that law. The point must be borne in mind with that fourth port of refuge, as I've painted it, is that there is a material distinction between practicing at the bar, where attorneys practice, and practicing on the bench, which is in front of the bar. And in the round, as I summarize now, I would think it, because of the inconsistencies that I've portrayed so far, I would think that it is not appropriate at this stage to abandon the Bar of England. I would think that the Commonwealth is a safe refuge, particularly when we look to the statistical output from the judiciary, where we have seen that the criminal law statistics, to be found at page 73 of the annual report of the judiciary of this year, demonstrates that we have a 40% disposition rate, 60% goes into arrears. We have the position where we only have at best an 11% probability of having a matter in the criminal jurisdiction dealt with inside of 1 year. We have had the statistical demonstration that if we wanted to clear the backlog on murder alone, we would take all of the judges of the Supreme Court, and assign them, all of the assize judges in particular, it would take every judge taking no new matters 10 years to cross the backlog. The last point that I'd make in relation to that is that with the advent of financial crimes about, well, burgeoning our country right now, because there are a number of financial crimes in the mix right now, and there is a considerably larger menu of same about to come. We do require specialist field endeavor on the judiciary insofar as they treat with things like terrorist financing, money laundering, etc., all of which I dare say don't really revolve around more than technically core areas, financial administration, balance sheeting, etc. So, Madam Chair, if I could say at this point, acknowledging the esoteric and philosophical bona fides of my learned colleagues' arguments, the government is regrettably not in a position to accept the recommendation coming from my learned colleague, Senator Mark.
Madam Chair, my colleague did not articulate or elaborate on the very important submission made by Senator Ramdeen. And that had to do with a judge coming in to our country from the wider Commonwealth seeking a work permit. And if he's seeking a work permit, he has to get it from the executive arm of the state. And what would that conjure up if a judge has to go to a member of the executive branch to secure a work permit?
I thank Senator Mark for that line of inquiry. May I point out, every person at the Caribbean Court of Justice, which is one of our courts of appeal for matters of original jurisdiction, save for Madam Justice Maureen Rajnath Lee, who is a Trinidadian, they all fall into that category right now. Secondly, the exemptions from work permit are perfectly permitted. Thirdly, the work permit functionality is addressed by a committee and not just the minister. Fourthly, the judiciary would have an ability in its separation of powers principle to certainly not accept a ministerial indiscretion, if I could put it that way, or intervention. So that in the round means it's been working and is working with respect to the CCJ. It worked and did work well with respect to Mr. Justice Brooke, who came from the Bar of England as a judge in the Assizes most recently. And also, there are remedies to treat with any form of malfeasance that could be treated with that way.
I'm sorry, Madam Chairman, will you permit? Honorable Attorney General, I think we are perhaps mixing things up because the CCJ is an international court. What we are talking about is the introduction of any Commonwealth citizen who has been admitted to the bar to be able to access our bench. That is the narrow point that we are looking at. So all this talk, with all due respect, about who sits on the Privy Council and who sits on appellate courts in other jurisdictions and so on really doesn't help us too much. Are you willing to consider perhaps putting a sunset clause on this so that we can see how, if persons from the wider Commonwealth are brought into the judiciary, we know a judge can't be removed except in circumstances, but certainly we will have an idea of how it's working and whether the law needs to be changed again.
Well, I respectfully disagree with your distinction as to the CCJ, because whilst it's an international court, it sits here in Trinidad and Tobago. Secondly, I'm not in a position to accept the recommendation for a sunset clause on an issue such as this. Again, I revert to the fact that if one were to take the argument of the Bar of England alone, that certainly is something which is 1964 move forward. The other position is that I respectfully also don't agree with the position that all that talk about the Privy Council is not relevant to the confines of Trinidad and Tobago, because the position as I see it, and again, I accept, Honourable Senator, that we may agree to disagree. The position as I see it is that that court, the Privy Council, is our final court of appeal, and therefore the functionality of the Privy Council in terms of our jurisprudence is as relevant in my mind as the functionality of the Supreme Court of Judicature, which is the Court of Appeal and High Court. So respectfully, I can't agree to, the government can't agree to a sunset clause on this position.
Madam Chair, the Honourable Attorney General made reference when he was submitting his case, work permits for judges. He talked about a category of exemptions. And I would have asked, I'd like to ask through you, if you could elaborate on whether the judges that are going to be coming from the wider Commonwealth to get into the bench, are you suggesting that they would be exempted from being able to access or require to have work permits? Is that what I'm getting? Just clarify for me.
I can't, armed with the information that I have now on this issue, answer that question yes or no. What I can say is that work permits are treated with under the ambit of a work permit committee. The work permit committee is permitted at discretion. Then there is the possibility of an appeal to the Minister of National Security. But any decision made by the Minister of National Security is also one which is subject to review. So I'm saying that there is an adequate remedy if there were to be an intrusion in this purpose to make sure that there was no abuse. The question is, can any abuse be managed effectively? And the answer to that has got to be yes.
Madam Chair, I just wanted to flag an issue for the Attorney General. Attorney General, with respect to the Privy Council and the Caribbean Court of Justice, I wonder if you would consider that those are third-tier courts, and therefore in 99% of the cases, those courts are called upon in making their determinations to give deference to findings of fact. That would be from the High Court and for the Court of Appeal in almost all of the cases. And what I'm wondering whether you're not concerned that the people that will come from outside of our jurisdiction and from far and wide in the Commonwealth, whether they would have the ability to properly determine findings of fact that may be intrinsic to a Trinidadian or to a Trinidad and Tobagonian and the culture in which we exist in here, especially for sitting in the High Court. I think Senator Choate in her contribution had made reference to the problems that can exist when you put, and you have flagged yourself that some of these judges may sit in the criminal jurisdiction. And also, I wanted to just tack on to that the fact that we have now not yet proclaimed, but we have passed legislation that allows for a judge alone. So you may well find yourself in a position where a defendant will be being tried for any crime in our jurisdiction that may be sitting without a jury, because I expect that one of your replies is going to be that, well, findings of fact are really a matter for the jury. But in a case where someone elects to have a judge-alone trial, don't you think it's quite dangerous to have a judge-alone trial for someone who is not acquainted with our culture or doesn't come from our background?
I thank Senator Ramdeen for not only raising the issue, but for also anticipating part of what the response would have been. And that is, of course, that findings of fact at present in the jury system are made by citizens of Trinidad and Tobago. And that also acknowledging that albeit not the norm, that it's still open to an appellate court to disturb findings of fact if they find that there's a manifest injustice with respect to same. I'm comforted, and I give answer to the question of the mischief or the expression of danger to say that the due processing of any court through its final stages, up to and including its final stage, is an adequate safeguard. So if there were to be any finding because of a failure to have cultural understanding of Trinidad and Tobago, then the process through the Court of Appeal and up to the Privy Council is an established mechanism and safeguard for due processing. Permit me to say this by way of a live example on this. I have sat in a court myself in a criminal assize where a Trinidad and Tobago judge would not accept the explanation coming from a witness, which was as follows. Redos did it. And then the judge went into a long discourse as to what Redos meant. And they went into an explanation onto the record as to what a red man in Trinidad and Tobago is. And quite remarkably, that judge was Mr. Herbert Volney. I sat in that court while that happened. It's one of those things that stand out in your mind. So Senator Choate had given us a very good example of an Englishman who had not understood local culture. And there I was faced with a Trinidad and Tobago judge not understanding what a red man is on the record. So I'm not quite persuaded that foreigners don't understand our positions necessarily, but I do fall back upon the position that the due processing through the courts is an adequate safeguard.
No, but Senator Choate, Senator Mark, at some stage you will appreciate that I will have to put the issue to a vote. I'm going to allow Senator Mark and Senator Choate one last intervention in respect of this amendment. Senator Mark?
Madam Chair, I know that is a very, I know, but this provision...
I understand. So go ahead, Senator Mark. Senator Mark, no, you go ahead.
Yeah.
I have given you the, yes.
Yeah, Madam Chair, this is a very disturbing and worrying and very dangerous matter that we are dealing with at the moment. And we, unless, there is some other objective or ulterior motive behind this provision, we have done our homework and we have sought to bring to the attention of the government a position that we believe that we can live with and parties can live with. If the government is insisting, Madam Chair, that they are not prepared to bend, they are not prepared to compromise, they are inflexible, then we have to draw our conclusions, and it would be unfortunate because I had my own thinking.
But Senator
No,
yes.
I'm just saying, Madam Chair, I'm just saying that I don't want to say exactly what I want to say here now, and I wouldn't say it. But I am just giving the Attorney General the opportunity, and we have given the Attorney General and the government the opportunity to meet the country and the people halfway on this particular amendment. And the Attorney General has rejected every effort. So one can only come to the conclusion what I had in my mind before.
Senator Mark.
There is an ulterior motive.
I will now call. Yes, Senator Mark. Senator Choate.
Thank you, Madam Chairman. Honourable Attorney General, as a practitioner at the bar, I must say that my concerns have not been allayed by what you've said thus far. And I'm just wondering whether comfort may be had for people who think like me, other practitioners at the bar, if you are able to tell us which of the stakeholders in the judicial system had been consulted during the process by which it was determined to have this legislation brought before Parliament.
Firstly, if I may begin and just put a quick answer to Senator Mark's submission. I don't accept Senator Mark's submission. I want to bring to the fore that by Act number 4 of 2010, the UNC had a clear opportunity to address concerns with the Bar of England, and it was not adopted. That prevailed, and the Bar of England allows for all of the so-called mischief, if one puts it that way, to have flowed in any event, because a citizen from any country coming through the Bar of England could have come. So for the last 8 years, since the last amendment by Act number 4 of 2010, I note that the UNC had been silent on any cure to any proposed remedy for some issue that they spotted. So I just wish to put that onto the record. Secondly, with respect to Senator Choate's question, the stakeholder request went out to a wide array of people. You said judicial system, I presume you mean more than just the judges, correct? Yes. So the request for submissions went to the public, they went to the Law Association, they went to the DPP's office, they went to the judiciary as three major participants in that. The Law Association did write in terms expressed by many senators, as expressed under the hand of Mr. Douglas Mendez of Senior Counsel, and that position was dealt with in the course of the debate with positions both for and against coming. Senator Mark's submission that this is dangerous can be also equally met with this is equally novel and solution finding. Thank you, Madam Chair. The criminal bar, well, first of all, the Law Association pitched out to all of its members. Every single member of the Law Association received the emails, received the bill, received the letters passing between the Law Association and the Office of the Attorney General. And that was allowed in the period June 29th, straight up till September when we returned, and even prior, because this stood on the order paper and was already with the Law Association. Law Association has in fact hired somebody from the Parliament who now works at the Law Association, and there is a constant tracking mechanism of all bills. So I want to say that there was ample time, there was written correspondence, there were positions put for and against. We've had 3 or 4 days of debate on this particular matter, and the government has made its position clear for the reasons espoused thus far.
Honourable Senators, at this stage, I will now put the question. The question is that Clause 3 be amended as circulated by Senator Mark. Those in favour say aye.
Aye.
Those against say no.
No. Can we have a division on it?
Mr. Khan?
No.
Ms. Gopi-Schoon?
No.
Mrs. Batiste Primus?
No.
Mr. Rambarad?
No.
Mr. Sinanan?
No.
Mr. Moses?
No.
Mr. Kazim Hussain?
No.
Ms. West?
No.
Mr. LeHunt?
No.
Dr. Henry?
No.
Mr. Singh?
No.
Mr. Cummins?
No.
Mr. De Freitas?
No.
Mr. Duki?
No.
Mr. Mark?
Yes.
Ms. Haynes?
May I repeat? Because I want it to be recorded. Yes.
Ms. Haynes?
Yes.
Ms. Amin?
Yes.
Mr. Saddam Hussein?
Yes.
Mr. Ubika?
Yes.
Mr. Ramdeen?
Yes.
Dr. Mahavir?
Abstain.
Ms. Ramkisoon?
Abstain.
Ms. Choate?
Yes.
Mr. Crease?
Abstain.
Ms. Raful?
Yes.
Ms. Phillips?
No.
Three abstentions.
Honourable Senators, 18 members, 15 members voted against the amendment, 8 members voted for the amendment, and 3 members abstained. The amendment, as proposed by Senator Mark, therefore, has not been accepted. Before I put the vote on the clause itself, I think Senator Hussain asked a question of the Attorney General.
Madam Chair, AG, with respect to the number of judges that we're increasing by, recently the number was increased by the Family and Children Division, and now we're going to increase again. Can you just give us the rationale for the figure of 65?
Sure. Madam Chair, it's bifurcated, firstly by an undercalculation in the Family and Children Division numbers. That court has approximately some 2,000 matters before it right now, so it has grown exponentially. Secondly, the government intends to aggressively return to the establishment of a family court in San Fernando, and that is a project for this year. And therefore, there is need for increased judicial capacity on that end. Thirdly, in anticipation of the creation of the criminal division, and specifically in the creation of specialist courts so that we can divide out the work, I can say that immediately we intend to begin with a sexual offences court because those matters have been dusted off and are ready to move. And this has been evidenced by the passage of 156 persons through maximum sentence indication over the long vacation which just happened last month. So we have aggressively operationalized. We've recalculated the numbers on the family and children boom, because that children's court literally went from 0 to 2,000 overnight. We intend to have specialist courts in the criminal division, which is a proposal on deck immediately for the sexual offences aspects. And thirdly, we expect that there will be a significant amount of financial crime for matters in the past, not only matters yet to come, that are about to come on deck. So there's a need for judicial capacity.
Sorry. How many specialist courts are we looking at with respect to the criminal division?
I couldn't say yet. That would be for the purview of the Honourable Chief Justice and the judiciary. But I am aware that the exhortations that we need to crunch the backlog have been taken seriously, and I have taken note of the Chief Justice's utterances thus far.
Thank you.
Senator Amin.
Thank you, Madam President. Just continuing on the same note, I understand your indication in terms of the need for more judges, in terms of the increased number of matters and so on. And I think what we're trying to get is if this is informed by some sort of research, has the judiciary provided any data to support a specific number, and how did you come up with that number?
Yeah, sure. Madam Chair, I did in the wrap-up of this matter on the last day that we were here, give us very solemn exhortation to all my learned colleagues to read Improving Court Services Through Process Reform Annual Report 2017 to 2018. And this particular volume has every bit of data down to probability of disposition on current numbers. And I've referred to the pages already, pages 73 onward, page 28, the backlog clearing. It is an absolute testimony of what is required, what is prescribed, and what has been recommended and is working. So all the data is before us.
If I'm not mistaken, this report came after the bill was laid.
Yes, I did say that it came the night before. It came the day of the opening of the court term.
All right.
But in terms of the data...
But that would not have informed when the bill was being drafted?
Yes, remember, the publication of the report is merely a publication. One obviously writes the report for at least 6 months beforehand. Right. All of that data was factored into the creation of this bill. So it isn't just...
The report didn't give a number.
Yes, there is a section in the report which talks to judicial capacity.
Yes, it spoke to the capacity.
I'd invite Melinda. Okay.
I'd
invite Melinda colleague to read it.
So I was just trying to gather. Thank you,
it's there.
AG.
You can read it.
Yes.
You can read it.
Senator Mark?
No, just asking. I think I got clarification. It came from the judiciary.
Okay.
That's right.
All right. So, honourable senators, the question is that clause 3 stand part of the bill. Those in favour say aye.
Aye.
Those against say no.
No.
Mr. Khan?
Yes.
Ms. Kobe-Schoon?
Yes.
Mrs. Batiste Primus?
Yes.
Mr. Rambarat?
Yes.
Mr. Sinanan?
Yes.
Mr. Moses?
Yes.
Mr. Kazim Hussein?
Yes.
Ms. West?
Yes.
Mr. LaHunt?
Yes.
Dr. Henry?
Yes.
Mr. Singh?
Yes.
Mr. Cummins?
Yes.
Mr. De Freitas?
Yes.
Mr. Duki?
Yes.
Mr. Mark?
No.
Ms. Haynes?
No.
Ms. Amin?
No.
Mr. Hussein?
No.
Mr. Ubika?
No.
Mr. Ramdeen?
No.
Dr. Mahabir?
No.
Ms. Ramkisoon?
No.
Ms. Choate?
No.
Mr. Kreese? Ms. Raful?
No.
Ms. Phillips?
Yes.
Yes. 10 against.
Honourable Senators, the result of the division is as follows. 15 members voted for the clause and 10 members voted against. So the clause 3, now stands part of the bill.
Clause 4.
Honourable Senators, the question is that clause 4 stand part of the bill. Senator Mark.
Yes, Madam, we have proposed for the Honourable Attorney General's consideration certain amendments which we have circulated. I believe you might be very amenable to these amendments. May I say that we are proposing in the definition of older child that we delete the words "in the opinion of the court before whom he appears or is brought is 14 years of age or upwards and under the age of 18 years, and to substitute in its place is 14 years of age and upwards and under the age of 18. As I said, Madam President, this has been circulated. I don't need to go through each provision that we are advancing, but suffice to say, it is all designed to strengthen this particular section of the legislation. I will call on my colleague, Senator Ramdeen, to further elaborate on these provisions.
Thank you, Madam Chair. Attorney General, if you look at the definition section, I understand your reasoning for including the definition of older child and younger child, being the differences within the age of criminal culpability. But there is one thing, and I want to make reference to. I see that you've included in the definition a part of the definition that is already existing in the existing law, which is in the definition of guardian. I have not been able to ascertain why in the definition of guardian, in the definition of older child, and in the definition of younger child, we are adhering to giving the court a judicial discretion to determine whether somebody is over 14 and under 18 or over 7 and under 14. And I just want to give you a practical example of something that is happening as we speak, right? It's not sub judice.
Before you go ahead, would you permit me?
Sure.
The reason is that we have been drawn to the example of where birth certificates can't be found, or we're dealing with adoption aspects where age is an issue. And therefore, the court has been called upon on umpteen occasions to actually determine what the age of the child is, because it can't be ascertained by records. This became very apparent when we were doing the insertion exercise for birth certificates, which is an exercise at the legal affairs end of the Ministry of the Attorney General and Legal Affairs. And we've come across hundreds of matters where we just can't determine age other than by way of circumstantial evidence. And that was the rationale for maintaining what the older law had.
Well, that I understand that. That's rational, right? But in most of the cases, right, all right, let me put my concern on the table. My concern is that you will have a case where there may be evidence that can be ascertained by virtue of the easiest thing is a birth certificate, because the age of someone is a definite fact, right, that is provable by your birth certificate. Now, I don't want a situation to arise where a court goes on a frolic of their own to determine in the absence of a birth certificate whether somebody is over or under the age of 18. And why I told you, let me give you a practical example. There is currently, right, somebody who is sitting in prison for 33 years under the sentence of death that has been commuted. And that person is only sitting in prison because at the time that they were convicted, the court was of the opinion, without any birth certificate or anything, that the person was over the age of 18. And I am concerned about the fallback position. I understand your rationale for having it there, but my fallback position is that how do we protect, or perhaps you could answer it this way, how do we ensure that where there is evidence, so that you can determine it by virtue of a birth certificate or something, that the court acts on that evidence and makes a proper finding of fact, and doesn't, in the absence of that evidence, proceed on the basis that I assume or goes on to some kind of process of finding whether the person is under or over the age of 18. Do you wish me to deal with all of them, or do you wish me to deal?
I know Madam Chair prefers that, but I find it rather difficult to answer 25 submissions in one round. I'll be guided by the Chair.
Does anyone else have a question or comment on that aspect of the proposed amendment? Then shall we move on to the other amendments?
Attorney General, I looked at the way in which older child and younger child is being used in terms of the Act for the purposes of the definition. And if you go to where it is referenced, which is 66. Sorry. Is it 99?
Should be
63. Sorry, 99.
99.
If you look at 99, you have a provision that references guardian in relation to an older child, which is in 99.3. If I can be allowed to take you to 99.3.
Sure, I'm there.
Yeah, 99.3, and if you go to 6 lines down, you would see that the purpose of this particular provision is to allow for the guardian, in the case of an older child, to exercise the election on the child being put to election for their criminal offense.
Mm-hmm.
And therefore, I thought that I didn't understand why there was an omission to define guardian in relation to an older child when you're taking out the definition of child. So I've asked for that definition to be put in the definition section in relation to an older child to just make sense of 99.3. You would see that you have it only in relation to a younger child.
Yeah. So look at your definition section. I've seen it. Okay. I've seen it. But we should replace child with younger child right through. So his point is that because it's referencing 99 with respect to the older child, it is perhaps that this definition should be for both. Right? Yeah.
Yes.
Madam Chair, may I be permitted, please? Because, first of all, I thank Senator Ramdeen for noticing something which is extremely important. But we're now down this avenue, and you haven't yet asked me to respond to the first one. You asked anyone else. I know that the preferred style is usually I take notes of everything, but that is, in my view, sometimes a little bit awkward.
But let's proceed on that basis until the awkwardness sets in.
Well, it has already.
Well, not really.
Well,
because it is simply all right.
We're on the second issue,
yes.
right? We're on the second issue,
yes.
So which is why I'm saying it's awkward, and I've not answered the first one yet. So the first one was a question on safeguard with respect to birth certificates. We're now down the second issue, which is why I'm saying it's awkward.
Attorney General.
Okay.
Yes.
Right. So if I could just wrap up the first issue answer, the Honourable Senator, I think, accepts that the need for judicial discretion is perhaps there because one way or the other we may have either a difficulty, as in the example Senator Ramdeen pointed out, or a genuine circumstance, as I've pointed out. I think that this will become less and less an issue as we perfect the digitization of birth records, and now we actually have records being done at the hospital. So it's really only in respect of persons who are adopted and who may come from abroad that we may have those issues. So I think that over time the system will take care of itself. but we prefer to maintain the judicial discretion because of the vicissitudes of the issue going one way or the other. Senator Ramlin has, in this submission with respect to Guardian, observed a very important point, that the amendment that we had proposed with respect to Guardian in the definition section, where we replace child with younger child only, that in light of the wording of 99.3, that there's perhaps a need for commonality, and that the definition of guardian should not be just for younger child, but it should be for both categories. That is everyone under the age of 18 years. So we would propose that we address that by way of an appropriate amendment. Would you permit me a moment to ask? Yes. So my CPC's team is suggesting to me that we can amend the bill in section, this would be at page 4 of the bill. What we would be saying is that in section 2 of the definition of guardian, by deleting the word child wherever it occurs and substituting the words younger child or older child. So we would just insert the words or older child. Sorry? Sure. Madam Chair, would you permit us a small... Okay. The CPC's department is saying that they are satisfied with what I've just suggested there. Yes, Madam Chair, but if I could just look at it in the, you see the amendment before us is Senator Ramdeen's, so I'm just now going to look at it in the context of the wording he's proposed.
No, I just asked for a new section, AG, so that you'd have them separately, so that you'd have a guardian in relation to younger child and you'd have a guardian in relation to older child. It's a matter of style.
You see, we could, you're happy with that? You see, we have a definition of guardian in the current legislation, and what we did is to just delete child and put younger child, and we really shouldn't have done that. We should have put younger child or older child both at the same point, so it's one common definition. So I'm proposing that what we should do in clause 4 is to amend clause 4B. Can you see it?
Yes.
Is to amend clause 4 Roman 2, no, clause 4B, and then as it's set out in the amendment, it would be in section 2, the wording stays exactly the same until we get to the end after the word child in inverted commas, that we insert just after those inverted commas and before the semicolon, the following words, or, open quotations, older child, and that would take care of it.
You just have just a typo, not really a typo, but a grammar. After, in your long definition that you have, I think you need to put an and after the second younger child.
Sorry, would you repeat that?
Sorry. In your if you look at the
marked up
summary quote that you gave to us,
yes,
which has the definition there,
yes,
you'd see after you strike the second child,
yes,
it says younger child, and I think it's supposed to be in and includes.
Yeah, so the marked up version is not the accurate as the bill says it version. So when we look to the text of the bill in 4.2, I think that that takes care of it, but just let me double check here.
4.2.
So if we look at the bill at 4B, sorry, at 4B, which is at page 10 of the bill
no,
itself.
it wouldn't cure it. It wouldn't cure the
in section 2 in the definition of guardian by deleting the word child wherever it appears.
You see, and is out of the principal legislation.
I see. So put in the word and before the words inserted.
Yeah, just have a look and see if it makes sense. After
Senator Ramlin, where are you specifically in the bill?
We're looking at the bill at page 10.
In
page 10
it would be, as the Attorney General says, at page 10, 4B, the second to last paragraph from the bottom. Page 10 of the bill.
Or. Younger child, or.
Yeah. But the only thing is that we are dealing right now with clause 4.
Yeah.
And I think if you...
Yeah, it's an and. So, Madam Chair, you see the words that I just gave to you? It would just be that we add the word and before the other words.
The second time it occurs.
The second time it occurs. So, Madam Chair, if you would allow the CPC's department to get the language in written form right for us,
sure,
we could perhaps treat with it that way.
Senator Ramkisoon wanted to raise something in the interim.
Thank you, Madam Chair.
In relation to, I would like to go back to the guardian definition,
Sure.
because I raised it at my debate where I asked about the definition for the child, because we were excluding the 14 and 18. But what I wanted to ask, if the Attorney General could consider just keeping the definition as it is and just taking out Section B altogether, because child means any person under the age of 18. And instead of separating it, because
I must explain why. So the definitions of younger child and older child fall into the manner in which those particular age categories are treated with from a processing in-court point of view. So this Summary Courts Act is when the child attends before a magistrate in certain circumstances, and where the magistrate calls upon the child to plead or address the court as to how they wish to proceed. There is a separation between the two. The younger category, you must have somebody acting with the child, because the child is not considered in terms of how the law treats that child as having the discretion or understanding to elect for himself or herself. It's different with the case of the older child. So we can't harmonize the two to say any child. It must be that within Section 63A, Section 99 of the Summary Courts Act, that we still observe the processes that these children are invited to be treated by the court, because there's an established jurisprudence on the back of that.
okay, so just to clarify, you have raised another point then, because younger child means 7 to 14, right?
Yes.
And older child means 14 to 18.
Yes.
And in your submission just now, you're talking about the younger child and 7. What happens in that case then?
So you need to turn, for instance, to Section 99 of the Summary Courts Act, where a younger child, that's the 7, is brought before a court for any offense, the child shall, as soon as possible, the court shall explain to him in simple language the substance of the alleged offense. 2, where a younger child is charged before a court of any offense other than murder or manslaughter, as the case may be, the case shall be dealt with summarily. In other words, then it's never dealt with indictably. You can't go the more serious, put the child before a jury and preliminary inquiry route. And it shall not be necessary to ask the parent or guardian if he consents, because in certain scheduled offenses, and the difference between indictable and summary offenses, you could have elected which route you wanted to go. What we're saying is, under no circumstances should this younger child ever be exposed to an indictable route. This child must always be treated within the, relatively speaking, softer route with lesser sentencing, etc. So it's rather complex in terms of how the law operates, but it is a safeguard for that cohort of child.
But Attorney General, if we go back to the definition, it says that we are, in relation to a child, which you're trying to amend now to older or younger, means the parent or other lawful guardian of such child. And that's why I'm asking you, in 99, you're giving the provision to not ask the parent or child. I mean the parent or guardian, sorry. So why would you want to not keep that age group in the guardian definition? Because you have the provision to exclude them, fine. So that's why I say, why don't you just simplify it and just have child, leave it as it is in the bill before us, the original Parent Act. That's my submission.
Is it in relation to what Senator Ramkissoon has just raised? Yeah? Yes?
Yeah. Attorney General, perhaps you could just deal with it in full one time. I don't know if it's a drafting error, but when you look at the way in which, and that's why I have proposed an amendment, you can tell me, the way in which Section 99 is structured is that you are given an election in relation to an older child. That is by virtue of subsection 3. Right? And you've just explained with a certain degree of clarity what happens, or the justification and the rationale for 2. But when you come and you looked at the bill in relation to subsection 4, it seems as though it includes older and younger in relation to what transpires in terms of process between 4 and the rest of the section, which goes all the way down to 8. So I had proposed, because I don't accept that 2 should be the law as it is, because I want to go with what you've suggested in terms of, I was trying to make sense of your suggestion at 5, because while there is an exclusion for murder and manslaughter in relation to subsection 2, there are a host of very, very serious offenses that someone who is between the age of 7 and 14 can commit. Now, I don't know when this law was promulgated, but I would like to think that we have reached a position where someone who is 12 or 13 Attorney General or 14, right, they should have the right or the understanding to be able to elect for a very serious offense. And therefore, I would ask that you consider with a great degree of caution whether we can't allow, as you're defining younger child and older child, and as you have already proposed in relation to 4 to 8, why we don't allow that same protection that the child has in relation to an indictable offense between the ages of 14 to 18, which is covered by subsection 3, that the younger child doesn't have that election. There are 2 people that the law recognizes to be the guardians, parents patria, the court, and the parent. And therefore, if it is that the child who is going to give that election, you're going to give that election to an older child at 3, I don't see, or I don't accept respectfully, not your suggestion, but I don't accept the present law as being in line with proper protection of that child. Because why should that child, I mean, let's ask you a question.
Senator, I think your point has been made. So, Attorney General, could you respond to Senator Ramdeen, please?
Well, I would have preferred to just hear the tail end of what the Senator was about to say.
Attorney General, please. Please.
Well, you're asking me?
Senator, all right, just one second. Senator Richards, you wanted to raise an issue?
Yes, thank you. Thank you, Madam Chair. Through you. I am in agreement with the Attorney General's differentiation, simply from what my training as in psychological assessment provides as best practice. There is a significant differentiation made between children at 7 years, as different to children 8 to 14, as different to children 15 to adulthood, because of the different stages of prescribed competence and cognitive ability and abstract thinking of children at those different age differentiations. And this has been established best practice in the world of psychology. And trying to amalgamate what a 7-year-old's cognitive and abstract thinking ability is with somebody who is 15, it is vastly different. So I'm in agreement with the Attorney General's approach on this.
Madam Chair, I'll try my best, because I was trying to distill the final argument that Senator Ramdeen was about to bring, but I'll work with what you've limited me to. There's a suggestion coming from Senator Ramdeen, which I thought is quite intriguing, and that is that we amend the existing law, which is not something that we had proposed to do. What we propose in this bill to do is to move up from 16 to 18, so we capture children in the definition as we now have it under the Children's Act. So we move from 16 to 18, that's the first purpose. The second purpose was to ensure that wherever that definition is now moved, so older child is no longer at 16 but up to 18, that we retrofitted it in terms of the language which we now use, in terms of the manner in which we engage what was once called juveniles and we're now calling child offenders. So that's why we've gone for younger child and older child to fit within the current terminology. We had left the law as it is, that is, battling with the age of discretion principle. Because there's a live debate in our country as to whether our age of discretion ought to be adjusted or not, and that's a product which we're taking consultative input on right now. But whilst I consider Senator Ramdeen's proposal quite novel, and maybe the way that we want to head eventually, I'm not genuinely yet equipped in terms of the final consultation to commit to that form of change. I mean, I can see the merit in the argument. I think that there's a certain benefit that can be brought that way. But the Children's Authority, the Office of the Prime Minister Gender Affairs Division, and our work with the United Nations and the juvenile, the rehabilitative approach that we're taking now requires a bit more exploration on that. I do accept the recommendation coming from Senator Ramley that we needed to do surgery to the definition of guardian, and that we should perhaps adjust the terminology for the amendment, that there be an amendment to 4B. And I don't know if you're minded yet to take that wording, Madam Chair? Yes? Yes?
I don't know.
This
is more
information.
I also propose another amendment in relation
Sure.
to.
May I ask Senator Ramley? Just so that I could,
Sure.
the further amendment you're proposing, is it apart from the amendment that the Attorney General is going to present for B?
I think he's on Roman 4, is it?
No, Roman 3.
3.
Because that's what you're dealing with now.
Mm-hmm.
Yeah.
Well, that was what I understood you were going to say when Madam Chair invited me to stop.
I'm lost as to which one we're dealing with, because
Roman 3.
Roman 3, right? That's what I'm saying. I propose an amendment to Roman 3. If you're leaving it as is, which is like the way you have proposed, I've proposed in my in the opposition's proposal that at the end of that section, are you with me on the substantive law?
Yes.
On 3, that after the word held, that I've asked that you consider putting in a sentence there that the court shall certify on the court record the response of the younger child, his parent and or guardian, as a safeguard on the election. Because there have been...
Thank you. Madam Chair, is it?
Did you get this finished? Yeah. The only reason I'm asking that, right, is I'm asking you to put in that as a requirement, as a safeguard, is because sometimes, in many cases, the election is done in court and there's an absence of anything saying hey or nay on the election.
I understand.
And in the absence of that, sometimes the entire trial.
We cured that most recently by the Children's Court rules. So we put that prescriptively into the rules. But I hear you that the intention is to look at it from the parent law perspective, right? Yeah. Madam Chair, could I indicate, and I don't know, you can guide me on how far I can go on this. We're in the course of preparing some tweaks to a miscellaneous package which will treat with preliminary inquiries, some aspects of evidence, and the Summary Courts Act. We're nearly finished with that, which we intend to bring just as we come back to Parliament in the next session. What Senator Ramdeen is referring to here, albeit that we've captured it in the rules, in the Children's Courts rules, we've dealt with it expressly, that you must record the answer, etc., etc. There may be merit in that suggestion, but I'm not best equipped to treat with that recommendation now. I can give an undertaking that we intend to look at it and come back, because we do have a bill drafted, a miscellaneous provisions bill, to treat with PI evidence and Summary Court amendments, and Summary Courts Act as well. There's several of them flowing, in fact, as recently as discussions with the DPP's office up to yesterday. So if we could undertake to look at that and to come back at that point, I'm certainly prepared to do that. Madam Chair, may I address, if it's convenient now, the proposed amendment to 4B? So, Madam Chair, if I could just read it as it ought to be, that there be an amendment to 4B of the bill, and it would say this: in section 2, in the definition of guardian, in inverted commas, comma, by deleting the word child, and here's where it gets new, the first and third times it occurs. So if I repeat that, the first and third times it occurs. And then it would continue, and substituting the words, open quotes, younger child, or older child, close quotes. And here it gets new again. And the second time it occurs, by substituting the words and it would be open quotes, younger child or older child, and close quotes.
Small amendment. First, third, and fourth. There's a fourth time.
Madam Chair, small tweak to what you've observed. And I will just say that this is what we've been doing for the last 2 years in the AG's office. You heard me repeat a short while ago the first and second time, first and third time. It really should be the first, comma, third and fourth times. Should it please you?
I'll just read it over, Attorney General, for members as well. This is the proposed amendment of the Attorney General. It's at page 4 of the bill, at section B. In section 2, comma, in the definition of guardian, by deleting the word child the first, third, and fourth times it occurs, and substituting the words younger child or older child, and the second time it occurs by substituting the words younger child or older child and. Yeah?
I apologize for the difficulties, Madam Chair.
That's fine.
And I thank Senator Ramdeen for the observation.
Yes, so Honourable Senators, the question is that Clause 4 be amended as circulated by Senator Mark. Those in favour say aye.
So just for clarity, Madam Chair, so I know how to answer, we're adjusting that which we just did as Senator Mark's amendment.
No.
No?
I'm putting Senator Mark's amendments as they have been presented, and then I will then go on to put the the amendment as proposed by the Attorney General. Okay?
Thank you,
Yes.
Madam Chair.
So, Honourable Senators, the question is that Clause 4 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. The amendment proposed by Senator Mark has not been accepted. Honourable Senator, the question is that Clause 4 be amended as proposed by the Attorney General and as read out by me. I will now read it over again. 4B, in section 2, in the definition of guardian, by deleting the word child the first, third, and fourth times it occurs, and substituting the words younger child or older child, and the second time it occurs by substituting the words younger child or older child and. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 4 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 4 as amended now stands part of the bill.
Clause 5.
No. Honourable Senators, at this juncture, I am in receipt of the instrument, and therefore I would like to resume the Senate, and we can deal with that matter. So the Senate will now resume. Honourable Senators, I have received the following correspondence from Her Excellency the President Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Ndale Young. Whereas Senator Ronald Huggins is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate with effect from the 21st of September 2018 and continuing during the absence of Senator Ronald Huggins by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's this 21st day of September 2018. Honourable Senators, a senator is required to take the oath.
I, Ndale Young, having been appointed a member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
Senators, we will now resume the Committee of the Whole.
Clause 5.
Honourable Senators, the question is that Clause 5 stand part of the bill. Honourable Senators, the question is that Clause 5 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 5 now stands part of the bill.
Clause 6.
Honourable Senators, the question is that Clause 6 stand part of the bill. Senator Ramdeen.
Attorney General, if you go to the DNA Act and the section that you propose to amend by Clause 6B, which relates to Section 13(2)(d) and Section 14(6)(d), 13(2)(d), you see that you're making provision. Are you with me? It's on page 8 of the on page, and I would prefer if you look at the one that you've supplied to us with the writings inside. I didn't understand when you marry this particular provision to the new Yoda, if I can call it that. There are provisions that allow someone to be charged, who is charged and in custody on remand, to be held at a community residence and a children's home as well. So by including rehabilitation center here, you've excluded someone who is being held, remanded at a children's home.
Yes.
Are you with me?
Yes, I am. And the reason is that we're not anchoring into the Child Rehabilitation Center Act. We're actually anchoring into the Children Community Residences, Foster Care and Nurseries Act, Chapter 4604, and the definition there of a rehabilitation center, which is a community residence, and then the community residence catches both ends.
Well,
so
how does that and this, it will help in a lot of different.
So unfortunately, the DNA Act references child rehabilitation center. So we call it a rehabilitation center, and we say it has the meaning assigned to it under Section 2 of the Children Community Residences, Foster Care Nurseries Act. So when we go to that, which I've also supplied to honourable members, it's in reference to Clause 11, however, we go to the definition there. We have the definition of, you see that page 2 of that marked up act, which I circulated around. Rehabilitation center means a community residence for the rehabilitation of child offenders who have been convicted and remanded.
Where
1 and 2.
AG, sorry, where are you?
So if you look to, I don't know if you've had it, forgive me, Madam Chair, is it okay that we jump this way?
That's fine.
Yeah? Okay, so if you look to the marked up act that I supplied, Children Community Residences, Foster Care and Nurseries Act.
Just give me 1 minute.
Sure.
Children Community Residences, Foster Care, correct, yeah.
Right? So this DNA Act references that particular act because we call a rehabilitation center, in the DNA Act, we use the term rehabilitation center, means that definition in the Children Community Residences Foster Care Act. So when you jump to that latter act and you look at rehabilitation center means a community residence, and a community center residence is in fact a children's home or rehab center. So that combined definition, rehabilitation center, means a community residence for the rehabilitation of child offenders in both categories, that is convicted and remanded, and or children who have been charged with an offense are in custody pending a hearing. So it's because the children's package was so closely knitted that the Children's Authority amendments, Child Act amendments, Children's Act amendments, Children Foster Care Nurseries Act, and what was UDA, that's how it's construed.
Just a very, and forgive me, but it's just a very, very untidy, and I say that not in any bad way.
I understand.
Because when if you follow the process that you've just said, rehabilitation center means, and I'm in the Children's Community Residences and Foster Care.
Yes.
Rehabilitation center means a community residence for the rehabilitation of A and B.
Yes.
And then you jump back now, right to the top definition, community residence means a children home or rehabilitation. It's just very circular.
Unfortunately, I was chained to how it came forward, and it came forward in a previous iteration.
I just was concerned that when you come to the DNA, that you don't leave out the ability that any law enforcement would have to capture either place. So if you marry it like that, and
I got you. We got both, but in 2012, when the amendments came up, that was the formulation that was used. So the Law Revision Committee is right now at work in trying to see how we could harmonize some of this. But that is only now at work.
I'm fine with that.
Thanks, Madam Chair. Thank you.
Senators, the question is that Clause 6 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 6 now stands part of the bill.
Clause 7
The question is that Clause 7 stand part of the bill. The question is that Clause 7 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that Clause 8 stand part of the bill. Honourable Senators, I will advise that there are amendments circulated to Clause 8 by Senator Mark, and there are amendments circulated by the Attorney General. I also will ask members, Clause 8 is very detailed, and I therefore would ask that everyone try and pay attention as we deal with the different parts of Clause 8. Okay? Senator Mark? Senator Ramdeen? So, Senator Ramdeen, how about you address the AG through me?
Sorry,
Yes.
sorry, I apologize.
Yeah.
Attorney General, let's take them one by one.
So let's deal with your Clause 8 amendment at A.
Right. But just before we deal with that, Madam Chair, through you to the Attorney General, I just wanted to flag something in section, Clause 8C, Attorney General, which I haven't proposed an amendment for the reason that I thought I would just ask you in the committee stage about it. This is on page 13 of the bill, right? Midway down, C, in section 2. Attorney General, I have a concern.
Look, Senator Ramdeen, I'm just trying to understand how. Is it that in dealing with Clause C, it sets some sort of context for the amendments that you have proposed at A and B? Yes?
Mm-hmm.
All right. So can you just succinctly say what is the issue?
Sure.
Yes.
Attorney General, what you have proposed to do is to create the YTC into a rehabilitation center, and that is a sui generis demarcation. My concern is that in C, subsection 2, I understand why you have taken out 4, 5, all of these sections.
The licensing for homes, yeah.
Right? But there are some sections that you may wish for your drafting team to look at between section 12 and section 22 that, and I will just make reference to one. You have proposed an amendment that was not in the marked up version that deals with the corporal punishment part.
Yes.
That fell in between 12 and 16. And I was looking for it, and then I found it in the bill, but it wasn't in the marked up version. And I just think that there are parts of those sections that you have made a blanket provision to take out, and I just haven't had the time to go through them individually. But there are certain protections in those parts that may be safeguards that you would want to include, notwithstanding the fact that you have the rehabilitation center at YTC as a separate category. Because I understand all the licensing provisions and stuff like that, but there are certain aspects of it. And let me give you one example. You've excluded out the policing, for want of a better word, of the Children's Authority over the YTC aspect of it. There are some parts of it that they're in, but if you look at these particular sections that you've excluded, there are certain parts that apply to what I would call the normal community residence rehabilitation center that is excluded here. I can't, forgive me, but I just can't pull them out individually now, so I just want to flag that. Let me go to the amendment that I have proposed at 2A, which is in D at the bottom of page 13. Right? You have proposed a new 2A, correct?
Yes.
Right, which says that the Commissioner of Prisons shall ensure that policies are prepared with respect to the following areas. And you've set out 4 areas, and then you have an omnibus provision at E, right? I'm flagging for you that this formulation, if it's passed in this way, could open up the Commissioner of Prisons to a judicial review. Because if he doesn't have these things in place at the time that this is passed, remember this is a bill that is passed already, we are putting our duty on him now to do these things. I don't know if you can help me with the state of readiness of these particular things, and I want to flag for your particular attention D, your D, which is the making of applications to court for permission for a resident over the age of 16 years to engage on-the-job training outside of a rehabilitation center. And why I flagged that particular one is because that has the ability to affect your access to court. And I'm saying my proposed amendment is that you take out the words ensure that policies are prepared with respect to, and you insert the word forthwith publish the policies that shall govern. It's for your consideration because you would know what stage this is at, but I'm just flagging that if we pass this as is and is not there, it's going to open up the commissioner for judicial review.
Madam Chair, could I ask for your guidance, please? There are letters A to N, that's O, 13, 14. There are 15 amendments proposed by Senator Mark, which Senator Ramlin is assisting us with. Do you propose that I wait for all 15, or do you want me to treat with them?
We're going to go through, but I need to ask Senator Ramlin something first. Your first paragraph, E. Is it that you have set out this amendment in relation to the bill or to the Attorney General's proposed amendments?
No, to the bill. To the bill.
So, at your A, where you say this is clause 8, and you say A by deleting in the new proposed subsection the following words. Where exactly are you?
At page 13.
8D.
8D?
Yeah, 8D to answer the chair's question, which is at page 13 of the bill. So it's in the original bill, not any amendment proposed by me.
Right, but it is not
Styled that way.
Yeah, it's not styled in the way of the bill. So it's a little difficult to follow it. You see what I'm saying? Yes. It seems that the A in Senator Ramlin's members, in the amendment proposed, that A is really in respect of 2A at page 8, correct?
No. It's 8D at page 13.
Oh, there's a different version. Yes.
Oh.
Yeah. All right. Yes, that's correct.
I see. Yes.
What he has done here.
KJ, I'm pulling from your copy. There's a problem.
But Madam Chair is right.
So have the proposed amendments been submitted in respect of the bill or in respect of because the A that you're talking about, Senator Ramdeen, we have an A at clause 8A in section 1 by deleting the words Child Rehabilitation Center Act and substituting the words Child Rehabilitation Centers Act. So there is some confusion.
I accept that, Maria. It is my fault in drafting the way it is drafted, but it really is in relation to page 8 of the bill, midway down the page, that is side noted, Commissioner of Prisons to make policies.
So, Madam Chair, in the bill itself, if I could assist, it's page 13.
Right.
And it would be a reference to 8D.
So here's what we'll do. Because the clause goes over several pages, let's deal with what there are no amendments for, so that we can just get through it, proposed amendments. So, for example, 8A, neither the Attorney General nor Senator Mark has proposed an amendment to 8A. Am I correct?
That's correct.
So can I tick that off for the time being? I think this will help other members follow.
I definitely agree. It's a clear approach.
Okay?
Yeah.
8B, I don't think anyone has proposed anything.
I have a clarification.
Sure.
With your leave.
Yes.
Madam Chair, to the Attorney General, the term or concept prohibited article, what is a prohibited article? And where are we going to find this? Do we have regulations that would define, or are we leaving that up to the discretion of the Commissioner of Prisons and the team that would be under his jurisdiction? Because it is not properly defined. And I think that when I was going through it, I said, I took a little note and I said, I'll ask through the chair, your good self, where is this prohibited article, defined? Is it going to be in regulations?
Yes, Attorney General.
So, Madam Chair, forgive the smile, but this is a definition. So it's being defined here. So prohibited article means, in the definition clause, any item, substance, or thing, A, B, C. And so this is the definition. And this definition has come about because we all have heard of the concept of shanks. In other words, then a toothbrush being made into a weapon to kill someone, or a piece of glass, or something which is otherwise innocuous in its normal state and condition, which can be mutated and altered to some detriment. So this is the definition for it. And this has come from the Prisons Authority specifically. Secondly, we also do have in the regulations further fine-tuning of some of these things.
That's what it's used. Okay, I think I'll wait on
so that
we have B, but under B we have Roman 1 and then we have A and B. Are we taking all at the same time? Under B?
if you have an issue
Just
that you want to
clarification?
raise, clarification, you can certainly raise it.
Under
Yeah?
B, right?
Yes?
Yeah, cool. Another one I'm seeking clarification on is under B, in terms of the article that you mentioned.
Yeah.
You have A and B. What is meant by the commissioner? It reads as follows: Commissioner to be a threat to the maintenance of security, good order, or discipline. What does that mean? Because you see, I'm saying that we are leaving with your children here who are in a rehab center. And from what I learned is that you're talking about any between the age of 10 and 18.
I think Senator Mark, the Attorney General, has a grasp of what you're asking. Attorney General.
Thank you, Madam Chair. Madam Chair, well, first of all, I just remind that we passed the regulations by way of affirmative resolution in this House. And this is the same definition from the regulations. So we've had 4 opportunities at this particular definition already. 2 in the House, 2 in the Senate. So it's the same definition. And what we're doing here is we're harmonizing into this law that particular purpose. And secondly, Madam Chair, because of what I just said a short while ago, because you can mutate or alter a toothbrush or a comb into a weapon, it really is left up to the supervisor, the person with responsibility for the prison, because it's in fact a prison, to have that discretion. So just to assure honourable senators that we've looked at this a couple of times well as a Senate on several occasions, and we've affirmatively passed this very definition in this session.
Okay.
Okay. So if we turn the page, we now arrive at 2A. Senator Ramdeen, is 2A where your proposed amendments are grounded?
Yes, Madam
All right,
Chair.
so would you like to now?
Madam Chair, sorry, just to catch up with you. So we dealt with 8B just now, right?
Yes.
And
We've dealt with everything leading up to 2A.
We didn't do C.
I see, which is D, which is what I'm asking.
We've dealt with everything because I look up to see if anyone wants to raise something.
Oh.
Remember, these are not, no one has asked for anything to be amended here, so I'm checking, I'm looking, and I'm moving along.
Agreed.
So we are now at 2A.
2D.
On page 8.
2D.
No, we're starting with 2A.
Of 2D.
At page
D.
8 for
8D.
all members. I am just trying to
8D,
keep
2A.
everyone, including myself, to follow what is going on here. So we are at 2A, page 8, Senator Ramdeen.
Which is D. D. Attorney General, I think I've explained the rationale for that. There are two aspects to it. The first one is what I've explained about when, in terms of it's just a time factor. And the second one, I think is the second one I think is quite important. I think you should want to consider it carefully, which is that these things that are being published by the Commissioner in a rehabilitation center that governs the management and the way in which things are to be done pursuant to your substantive provision in the Act will make no sense to anyone. Say, because the persons who are affected must know what they are, and therefore just there is to draw an analogy, there is a similar provision in the Prison Rules 1838, even though they're so dated, that the prison rules themselves, when they're made, are to be brought to the attention of those persons, the inmates who are incarcerated. And therefore, apart from the suggestion that I've made to you in relation to 2A with the Commissioner and when it is to be done, I've also suggested to you that we add a 2AF, which is that the policies published in accordance with Section 2A shall be brought to the attention of all residents of the rehabilitation center. And I think it's quite important because these are the things that directly affect their conduct. And I would also expect that when you publish your rules that go along with these things, that they would be brought to the attention of the residents, because there would be the failure to do any of those things would amount to some kind of breach. So I thought as a safeguard that we put in an F that would include what I've suggested.
May I, Madam Chair? Madam Chair, I thank my learned colleague for the caution, and I think it's so well pointed that we ought to, when we come later to the introduction of new clauses, we should perhaps include a proclamation clause.
Yeah, that's what I was checking.
Yeah, so we will be proposing a little bit later the insertion of when we get to new clauses, the insertion of a proclamation clause, which would allow us to then partially proclaim as we go and we checklist out what is ready or not. But to answer the question, we're actually ready for this now. So first of all, we're operationally prepared, and we actually have the mandatory aspects in the regs that you, upon admission of a child to the center, must explain to the child. They must acknowledge, the rules must be handed, it must be done in a language that the child can understand, the care package for the child is then published. So all of these things are mandatorily provided in the regulations themselves.
Would there be any harm in putting in relation to these? Because I'm not sure that these would be covered by the regs. That's all I'm asking. Sure. I understand what you're saying, which is those that are covered by the regs, no difficulty. These that are now going to be put in place.
Sure. Would Madam Chair, you allow me a moment? So. So, Madam Chair, it is certainly something which is very amenable, that the 2AF could be introduced. Policies published in accordance with 2A shall be brought to the attention of all residents of the rehabilitation center, and mainly because it's done in the regs, but if it's done there, why not put it in the parent law?
And are you prepared to leave 2A, the top part, as is?
The ensure forthwith, well, we have a mandatory provision. The forthwith sort of causes me some concern in terms of the immediacy of that.
The only reason I put it in is because I actually looked to see if there was a proclamation clause, and there wasn't any.
No, there wasn't, which is why I thought that we could invite Madam Chair to consider the introduction of a proclamation clause.
Well, and through you, Madam Chair, if you're going to do that, perhaps you can take out the word forthwith, and you can put in there a time period that fits in with the fact that you have a proclamation clause, which you can say 30 days or 60 days or whatever you might.
As we have it now, the Commissioner shall ensure that policies are prepared with respect, and then putting in the 2AF, which says, then putting it in later as a new 2B, that he shall ensure that it's given to all residents. I think that those two should achieve the purpose.
Once you're sure that it's done, because if it's not done, giving him a period of time, for example, giving yourself, let me put it this way, giving him 30 days or 60 days will give him that window upon proclamation.
Yeah.
So you could have put it in to give yourself that safeguard, because as it is now,
understood.
If you proclaim and it's not there, LGR.
Right. So, Madam Chair, I take my learned friend's colleague. It's a very practical suggestion. But just to say that we've actually prepared all of these already. So we're ready for that, and the proclamation clause will take care of us being able to. What we do is we do a proclamation schedule to ensure that we've checked all boxes before we actually proclaim. That's the way we go about it.
So, Attorney General, are you suggesting that we incorporate what Senator Ramlin has at B? So we will insert a new 2AF.
Madam Chair, we would propose a slight surgery to that.
Okay.
We're proposing that instead we insert a new 2B. So as it is now, we're proposing a 2A. So we'd propose a fresh new one, a standalone, which would be a 2B. So it would be that we insert into clause 8D a new 2B. Because remember that 2A falls under 8D, right? So we're proposing in D, by inserting after subsection, section 2, the following new section. It really should be the following new sections. So in the chapeau there, it would be sections. And then 2A would read as it does. And then we'd propose that you have a 2B. And the language for 2B would be the policies published in accordance with section 2A, exactly as Senator Ramlin has suggested. Right, and we just spell center with an RE as opposed to an ER.
Residents to be notified.
All right, I got you. And
Getting that, right?
And Madam Chair, just when you're ready, a small adjustment to the marginal note as well. Right, so the marginal note, Madam Chair, where it says Commissioner of Prisons to make policies, there'd be a marginal note to 2B, which would say residents to be notified. Right, and Madam Chair, if you're looking in the text that came from Senator Ramlin's draft, instead of the rehabilitation center, the last three words, it really should be a rehabilitation center.
Senator Ramlin, will you continue on your
Sure.
your proposed amendment?
Child issue for the next amendment, I need your subsection. We are at E, which is in your page 14 in section 3, by repealing subsection 1 and substituting the new subsection. You with me?
Halt again, Senator Ramlin. Go say that again.
We are at E in the bill. 8E.
Page 14
page
of the
14
bill.
of the bill.
Yeah, E.
Yes.
Now remember, in your this was to cater, Attorney General, for the fact that you have excluded certain provisions. I'm trying to follow it here now. for the Section 2A of the bill.
Well, this was specifically to marry up the Children's Authority.
No. This is to give you some protection in relation to your exemptions of the Children's Authority from the Rehabilitation Center. You understand?
Yeah.
Where you would have taken out the same provisions that I spoke about, which is in your Section 2.
Yeah.
Right? Roman 1 in the bill.
Yeah.
Right? When you come to your new Section 3, would you not want to have the protection of saying subject to that, because that is the part that you're taking out? Because you're actually applying.
I understand.
And
do you understand this? Yeah, so we're saying a rehabilitation center shall be under management local subject to Children's Authority Act and Children's Community Residences. Right. What we did here is we notwithstood clauses 8, 22, etc. Right? So he's cautioning here in 3 that we did the notwithstanding section, right? The disapplication aspects. So the question is whether it'll be read that way in law, or should we, out of an abundance of caution, put the notwithstanding factor?
Don't you say subject to
Yeah.
and we have disapplied,
it will clash
together,
Yeah.
and you will see that those that didn't apply will not apply.
May I respond on this, Madam Chair? Yeah. So I thank Senator Ramdeen for raising the issues. So if I try to clarify it this way, I'll put it this way. Senator Ramdeen is cautioning, because we amended Section 2(3) of the Parent Act by making the exceptions for children's homes in the manner that we did, which is where we took away the licensing, etc. Because we did that, he's pointing out that there may be a need for caution when we're introducing this new subclause 1 to Section 3. Because Section 3 would be saying a rehab center shall be under management and control of prisons, subject to Children's Authority Act. And here's the bit, and the Children's Community Residences Foster Care Nurseries Act. So what Senator Ramdeen is cautioning is whether we need to make that exception which we did above. But I'm told by CPC's department, and I agree with them, that having made the exception, the disapplication of those provisions of Children's Community Residences Foster Care Nursery Act, that we don't need to do that cross-reference, because there may be other laws which cause amendments which we have not factored in the one that we've done now. But I take the caution.
No, I'm listening to you. You're true?
Yeah.
Okay.
If that is the position, I'm fine. I'm fine in withdrawing my proposed amendment, which is my C. So then you can have E as approved. E is approved, as is in the bill.
D is where? F. D already. F. So we've done D, we put in the new 2B, and we just did E. Yeah, so now we're on to F.
No. Let's see what I'm looking at his yes. Yeah.
Is that
what is the next amendment you're seeking, Senator Ramdeen?
For 1A, the AG's new proposed section for 1A, which is one that is lifted out of the community residences foster care.
So that's GA, Madam Chair.
Yeah.
So that is, we're now dealing with your amendment as well.
Yeah,
your proposed amendment.
So I take it, Madam Chair, just so I keep up with you, right? That we're now moving past E, F, G, and coming to GA, yes?
Yes.
Right. So, do you want me to address the GA, Madam Chair?
Well, I'm trying to get through Senator Ramdeen's so that I can then see where they marry with the amendments proposed by the Attorney
Understood.
General.
Sure.
Okay? So, Senator Ramdeen, perhaps you would like to talk about your proposed amendment?
Yeah. My proposed amendment, Attorney General, is that I appreciate that you've put in this section But when you come to, there are two things that arise. Firstly, when at page 15 of the bill under GA, you have where a person alleges that a resident at a rehabilitation center has been the subject of any form of the prohibited methods of punishment referred to in subsection 1. The person shall report the matter to the Commissioner of Prisons and the authority, being the Children's Authority. Well, after that section, there is no provision as to what takes place thereafter. And I think it's in a matter that is so serious relating to corporal punishment, restraint of force as a form of punishment, the reduction in diet, and denial of a family contact. I propose that we add a safeguard in the form of a new subsection 3 that would be where an allegation is made to the Commissioner of Prisons and the authority. It could be and the authority, yes, pursuant to subsection 2. The Commissioner of Prisons and the authority shall forthwith conduct an investigation into the allegation and notify the person making the complaint of the findings of the investigation upon completion. There would be, I just speaking from experience, these things happen almost all the time.
Yeah, yeah.
And
Any complaint is there in regulation, but detail.
Sorry. Yeah, Madam Chair, may I?
Yes.
Is it okay?
Of course.
Okay. I accept the bona fides of the submission. I was just double checking because I had recalled it vividly. We did it in the regs. So if they're in the regs, there would be no harm in including in the parent law, certainly. And it certainly is.
If you can get the wording, I'm fine.
So I was just literally leaning over to CPC, asking if we had the wording from the regs so that we could harmonize the two. Just permit me one moment. Is it convenient?
Of course.
Yeah.
Say something about this too much. No. Yes. You are your building below this. 2A.
Madam Chair, perhaps I may suggest while our team is looking for that particular language, is it convenient for us to press on and just put a little marker next to this one?
Yeah.
Madam Chair?
Sorry.
We don't want to get it wrong.
So we will stand down that part of the amendment proposed by Senator Ramdeen. Senator Ramdeen, can you move on to your next?
Madam Chair, just to clarify, this may assist. So what Senator Ramdeen just referred to was actually an amendment to my amendment, which we haven't come to yet.
Which I know, but we've stood it down. It's fine.
Right?
Yes.
It's okay?
I'm clear.
Because we could pick it up in my amendment.
Yes. Senator Ramdeen.
Evie, I think this one struck me as being quite important. You've created an exception to the forms of punishment that are not permissible, that you've prohibited by the Act. And while I understand A, B, and part of C, look, if we look at it, for the safe custody during removal of transportation from the rehabilitation center, no problem. On the direction of the medical officer, no problem. For the purpose of preventing a resident from injuring himself, no problem. Damaging property, no problem. But Roman numeral 3, Attorney General, I really want to caution us including that, which is creating a disturbance, because creating a disturbance is too, in my respectful view, is too wide a catch-all discretion to allow a Commissioner of Prisons to put to impose these kinds of punishments on somebody.
Attorney General.
Yeah, Madam Chair, this is something that we wrestled with for months, literally. And just to inform that the table that sat to come up with these thoughts included the Children's Authority, the prisons, the judiciary, the family law practitioners, etc. So we had a long round table of conversations on this. The prisons officers in particular were cautioning that some of these children are not just children, because we're dealing with under 18. And the disturbance factor is something that they have to manage, because it can actually get up to a riot stage at some point. So what we sought to do in treating with it, because obviously it could be quite capricious to say any disturbance, right? What we sought to do was to put in the safeguards for it. Who must know, the supervision of it, the reporting of it, the ability in 2A, as we've amended it, to have the Children's Authority in lockstep with it. So that means that the child attorneys also get involved in the Solicitor General's department if they are brought in on that whole perspective. So the prison was very, very, very insistent that whilst they agreed that for the first time we should start to limit these forms of discipline that they otherwise had under the Prisons Act, because we're now prescribing these downward. They really wanted us to make sure that we didn't throw the baby away with the bathwater in how we treated with the disturbance aspect, because it's severe.
Well, I understand why they do that, because I could probably speak from a different perspective from everybody else. I mean, creating a disturbance, while I accept could be as much as reaching up to the riot stage. On the other extreme, it could be somebody has an altercation with a prison officer, and one of the residents simply say, "We ain't taking that," and everybody jump up and a whole disturbance starts with that. And while I accept you have to caution on one extreme, the other extreme is that the bar is put so low that almost anything falls into creating a disturbance. I mean, I've done a case where a plastic bag went out of a man's cell, and they had a riot in Port of Spain, and everybody get licks. And that's how it works. I just think, while all of these things are here, I just think creating a disturbance is so wide.
So Madam Chair, is it okay?
Yes,
It's a really important point, and if you'd permit me to just put the counter this way. So we're moving from a situation where you can use all of the methods right now, and we're now for the first time saying, look, you can't do these things, and we're creating the exception. And the Prisons Authority was very, very keen to make sure that we took this in a gradual step, because the counter to that of somebody walking in to say, look, you can't discipline me at all, became an Achilles heel in many senses.
Madam Chairman, sorry. Would it be possible then, because sometimes you have to create a disturbance or attract the attention of an officer when an inmate is ill and that kind of thing because of the low staffing at these institutions. Could we not qualify it by saying an unnecessary disturbance or something like that?
I think that's a very laudable suggestion, but the difficulty that I had there is what is necessary versus unnecessary, and therefore whether one has a right to cause a disturbance per se. So how to draw that line in the sand is
well,
something
Honorable
I'm wrestling
Attorney
with.
General, I have experienced instances where men have died with other inmates causing a disturbance, trying to get medical attention for the dying person in custody. So it is not something, Senator Ramdeen's point, with all due respect, is not one to be dismissed lightly. There certainly can be no harm by qualifying the words in that way.
Just say what is happening right now. It is becoming clear to me the way we are proceeding. There are some administrative problems, and let me explain what I mean by that. The Attorney General has circulated amendments to the bill that is before us. Senator Mark has circulated amendments to the Attorney General's amendments and not to the bill. We are now treating with Senator Mark's proposed amendments, 2 amendments that have not even been sanctioned as yet. And so administratively, we are running into some issues. And I'm seeing from some of the senators' faces that there is confusion. And while my face may not show confusion, I will tell you it's not a very happy face right now because some of the issues are really, it's becoming a little unwieldy. So what I am therefore going to do at this stage is suspend. When I return, I am going to treat with the Attorney General's amendments. If Senator Mark wishes to further amend, then we will treat with it like that, because the amendments as submitted by Senator Mark, you heard, are 2 amendments and not to the bill. All right, so I'm going to suspend at this stage. We will take an early break. We will return at 10 minutes to 5, and hopefully when I return, we will start with the Attorney General's amendments, go through. If there are further amendments to be made, we'll incorporate it at that stage. So we are suspended until 10 to 5.